Welcome back everyone. Today I'm going to review this book 10 Judgments That Changed India by Zia Mody. This book talks about 10 very important judgments that changed the course of Indian society and the way India worked after these judgments were delivered. This book was written in 2013 and the author of this book, Miss Zia Mody, is a corporate lawyer and the foreword of this book is written by her father, Mr. Soli Sorabjee, who is a senior advocate and was the Attorney General for India. The book, as the name suggests, throws lights on 10 very important judgments, and these judgments changed India very fundamentally. The book talks about these cases' backgrounds as to what led to these cases being filed, and then it gives us arguments that were advanced by both the sides, and then the judgment that was delivered by the court finally, and then the book also analyzes the after effects of the judgments when they were implemented. Now I'll briefly discuss all of these 10 judgments with you. The first judgment is certainly the most famous judgment in the polity of India is Keshwanand Bharati case, Keshwanand Bharati versus Union versus State of Kerala. The court had to rule whether Parliament can have amending powers that are unbridled and unlimited. The court ruled that the Parliament had amending powers, but it cannot amend the basic structure of the Constitution. Now, the interesting story behind this case is that the sanctioned strength of the Supreme Court at this time in 1973, when this case was being heard, was only 14 judges, and 13 judges sat on this bench that decided this case. The hearings went on for 69 days, and that is a lot of time. So during this period, the court was hearing this case, and there were other cases also that had to be heard. So what was done was that for the rarest time, ad hoc judges were employed in the Supreme Court, and this is one of the powers that are not used very easily, and we can even now observe that ad hoc judges are not appointed in the Supreme Court at all. But that was the time when this constitutional case was so important that ad hoc judges had to be appointed so that the permanent judges could hear this case. Now there are some other issues also about this case. I'm telling these stories because I am aware of this. This story is not given in the book. The book talks about the judgment and the way I told how the book discusses it, and this judgment is quite popular, but the story about this is not so popular, so I'm telling the story. The bench was very divided even during this period, so because of Indira Gandhi's attempts to browbeat the judges, the judgment delivered was also very complicated because 13 judges sat on this bench and every judge wrote his own opinion, and then to make it easy for the public to understand, for everyone to know that what exactly the court wanted to say, the court also issued a statement that in brief told what the court has opined. That statement was drafted and it was circulated to all the judges, all the 13 judges, but 4 of them refused to even sign that statement, saying that they don't agree with it. So this was the kind of the division that was there in the bench during that period. But this is the judgment that saved India's democracy, and this is one of the most fundamental judgments in the history of India, and I think this is always going to remain so. The next case is Menka Gandhi versus Union of India. In this case, the Janata Party government in 1978 asked Miss Menka Gandhi to surrender her passport to the passport office. This was also seen as a way to browbeat her and to victimize her, because she belonged to the Congress party, and the court ruled that the expression used in Article 21, which is procedure established by law, will have the same effect as that of the expression due process of law. What this actually means is that the law should not just be made by Parliament. The fact that the law has been made by Parliament does not make it automatically to be valid and constitutional. The law has to be fair, just, reasonable, and then it will be deemed to be valid. Through this case, the Supreme Court also transferred to itself from merely being a supervisor to being a watchdog of the Constitution. But do you know that the Supreme Court verdict in this case did not actually tell the authorities to return the passport back to Miss Menaka Gandhi? This is also one of those kinds of judgments that the Supreme Court delivers, where the relief is not granted to the petitioner, but the Constitution is interpreted in a brilliant way. But the petitioner always, keeps looking for where is my relief. One of such judgments was also delivered recently in Jammu and Kashmir 4G resumption case, which is known as Anuradha Bhasin case. In that case, the Supreme Court ruled that the right to, the six freedoms have inbuilt in them the right to freedom of expression and speech and right to trade, which are both facilitated by internet. But the Supreme Court said all of this and interpreted the Constitution in such a liberal way, but did not order the resumption of internet services in J&K. So ultimately, the petitioners were denied relief even in this case. The next case is Supreme Court Advocates on Record Association versus Union of India. This chapter is basically upon the independence of judiciary and how it was secured, and the evolution of collegium system and how it was invented by the court itself. This chapter is about how the appointments of the higher judiciary will be made in India. There are in total 4 judgments about it. The 4th one came in 2014, but this book was written in 2013. So the 4th judgment is not there in this book. The first case is called SP Gupta versus President of India, and it was ruled in 1981. The Supreme Court had held that the government cannot transfer any judge as punishment. They also ruled that the opinion of Chief Justice is not to receive primacy while appointing any judge. So this meant that now the government was having the last laugh when any judge had to be appointed to the court. Then there was another case which is called Second Judge's case. The name of this case is Supreme Court Advocates on Record Association versus Union of India. In this case, the court had held that the judiciary and the executive will have an equal say in the appointments of the judges in the higher judiciary. But then came the most landmark of all these cases, which led to the creation of the collegium system. It's a presidential reference that was sent by President K.R. Narayanan to the Supreme Court to seek its opinion. A 9-judge bench of the Supreme Court delivered a unanimous opinion in this judgment, and they ruled that the collegium will make the appointments and not the executive in any way. Collegium will consist of first 5 judges of the Supreme Court while matters relating to the Supreme Court, and the first 3 judges of the Supreme Court where matters will be relating to the High Courts. Now let's talk about the NJAC judgment that is not given in this book because this book was published earlier than that judgment was delivered. NJAC is National Judicial Appointments Commission, which was made by law by the Parliament to appoint the judges in the higher judiciary, and its composition was that there will be Chief Justice of India and 2 senior most judges of the Supreme Court, the Law Minister, and 2 eminent persons will be there. This law was passed in 2014 and was struck down by the Supreme Court in 2015 as unconstitutional and void, as the Supreme Court believed that the judiciary should be kept insulated from political executive, and it wanted to give its autonomy away to the executive in any way. Now I'll talk about the other cases very briefly. There is a chapter on the Shabbana case that paved the way for Muslim women to receive maintenance from their husband when they got divorced from them. This judgment was nullified by the Rajiv Gandhi government in a law that was passed by them in the parliament. The next case deals with the right to livelihood by slum dwellers or pavement dwellers, and it was a case of pavement dwellers in Mumbai. What happened was that there were a lot of migratory laborers that came in Mumbai and they settled on in the slums or pavement dwellers. So what the BMC wanted was to evict them and then to send them back to their places of origin. But the Supreme Court in this case actually recognized their right to livelihood, and they said that their right to life is not possible until they get a right to livelihood, because they migrated to such big cities because they were not getting good work in their own cities. So in this case the Supreme Court ruled in favor of BMC, but the BMC gave a lot of assurances to the court that they will give alternate accommodation to these migrants. There will be schemes for rehabilitation, etc., for these people. Here the court recognized that these are poor people who migrate to such big cities and they want to seek work, and that is how they are going to realize their right to life. The Supreme Court in this judgment also took very humane view of the condition that these slum dwellers and pavement dwellers faced. The court said in its judgment that those who have made pavements their homes exist in the midst of filth and squalor, which has to be seen to be believed. Rabid dogs in search of stinking meat and cats in search of hungry rats keep them company. They cook and sleep where they ease, for no conveniences are available to them. Their daughters come of age bathe under the nosy gaze of passers-by, unmindful of the feminine sense of bashfulness. The cooking and washing over, women pick lice from each other's hair. The boys beg. Men folk without occupation snatch chains with the convenience of defenders of law and order. When caught, they say, who doesn't commit crimes in the city? Some of the other judgments discussed in this book are Bhopal gas tragedy related cases and how the justice was delayed for so long in these cases, and Indra Sawhney judgment, that is a very famous judgment for that tested the constitutionality of reservations in India under the constitution. Then there is a judgment on custodial deaths that developed the custodial violence jurisprudence and recognize the rights of victims to be compensated for the violation of their fundamental rights. There's also Vishakha judgment that developed the jurisprudence to prevent sexual harassment at workplace. Then lastly, there's this judgment by the Supreme Court that legalized passive euthanasia, and this is not given in the book, but the starting of the judgment is very interesting, and the judgment is written by Justice Karju. He has quoted Mirza Ghalib, a couplet from him, and the couplet goes, मरते हैं आरज़ू में मरने की, मौत आती है पर आती नहीं. So this is a brief summary of the book, and the language of the book is sometimes a little tough because many times the excerpts from the Supreme Court judgments are quoted, and anyone who reads judgments knows that anyone and everyone does not understand and is not able to understand the judgments, because they don't only just deal with complex questions of law, but they are answered also in very complex ways. And the book can still be read by anyone who wishes to read it, because ultimately the author explains what the court means. And thank you very much for watching this video. I'll be back next Sunday with a new video, with a new book review. Till then, take care, stay safe.